SJC-10845.
Good morning, Counsel.
Good morning, Mr. Chief Justice. If it please the Court, just an observation to begin. I think the first time I was here was in 1978. When I looked up, I thought, this Court is very old. You look very young to me today. Very young.
I thought that's what was going to follow, and you still do.
Very young. This case is here on further appellate review from a decision by the appeals court, where the appeals court said that I was arguing some sort of abstract level of propriety. Abstraction is not my strong point. I think this is a very concrete case, and I can think of no more egregious misrepresentation or lie that a police officer could tell than a misrepresentation or lie about a suspect's constitutional rights.
Well, I don't believe in hypotheticals either, but why aren't all of the circumstances relevant here, and why isn't, on the basis of all the circumstances, it fairly reasonable to conclude that this wasn't involuntary? This wasn't the kind of manipulation where, let me advise you of your rights, and oh, by the way, if you want to talk to me, we can talk off the record. I mean, that's an undermining of a specific required advice of rights, but that's not what happened here.
It's exactly what happened here.
Did it really?
Yes.
I don't remember there being an advice of rights and saying, but pay no attention to what I just told you.
No, there was an advice of rights, which was the suspect or defendant says to the police officer, can I talk to you off the record? And the police officer says, yes, you can talk to me off the record. He admitted at trial that that was just a bold-faced lie. He never had any intention of talking off the record. That is a direct contradiction to the Miranda warning that says anything you say can and will be used against you in a court of law. So Miranda warnings are only required in the context of a custody situation. But your constitutional rights are the same, whether you're in custody or you're not in custody. We have a prophylactic rule about ensuring that a suspect in a highly coercive situation, namely custody, is actually told out loud what his rights are.
But at the end of the day, this is all about whether it was involuntary in some fashion.
Correct, Your Honor. It's a balancing test, and there are a lot of factors that go into the balance.
Don't you, I mean, Judge Fishman, at least I read this footnote as suggesting that what the officer meant was, I agree it won't be part of the written statement.
I don't believe that Judge Fishman says that at all. I think he specifically says.
It's on page 22 of your addendum.
He says, not at the footnote, but at the top, he says, of 22, the only arguably coercive factor present here is the fact that the defendant could have reasonably understood that Trooper Cummings had agreed to the defendant's request that a limited portion of his oral statements be off the record.
Right?
Yeah. So
Cummings didn't, okay, I guess I'm just suggesting you sort of have this, he could have believed that, Cummings didn't mean that, so it's sort of who wears the risk of the error, right?
Well, Cummings lied to him. Cummings specifically told him, don't worry, nothing you say will be used against you in a court of law, when he meant everything you say will be used against you in a court of law. This is a double whammy that the defendant.
Does it say that? He says those words? Nothing
No, but that's the equivalent of saying it's off the record. It's this is what off the record means, that I will hold it in confidence, and it's just between you and me.
But I mean, defendants frequently say, look, I'll tell you, but I don't want it on tape.
Right, that's very different. I think the language is very important. On tape means you're not going to have a recorded conversation that can be played for others. So, I can always deny that I said it.
It's not in my statement. This is my statement. This is what I wrote.
Off the record, we can argue about what off the record really means. I think it's absolutely clear what off the record means, which is that it's confidential. It will not be used against you. This is an anti-Miranda warning. And in a balance, this is the 2,000-pound elephant in the room. It's conceivable to me something else could outbalance this, but I don't know what it could be. A defendant saying, well, you say it's off the record, but I have my strong suspicions that you're really going to use it, but I'll talk to you anyhow. Well, maybe that could change the balance. But I don't know how you can authorize anti-Miranda warnings.
Is this a Miranda issue, or is this a voluntariness in the Stovall v. Deno?
It's a voluntariness analysis, but to me it's just like the Fourth Amendment context. The Fourth Amendment, just like the Fifth Amendment.
If the police officer had said to him, if you tell me what happened, I promise you won't go to jail.
Well, to me that's less egregious than this, because that is just that's also a lie. And it's intended to undermine someone's right to remain silent, but it's not a direct contradiction of the Miranda warnings. And the Miranda warnings are just an articulation of what a person's constitutional rights are. And as in the Fourth Amendment context, it's perfectly appropriate in non-custodial situations not to give the warnings. Just like in the Fourth Amendment, you don't have to say to someone you have a right to insist that I have a warrant. You don't have to say that. But you can't say the exact opposite. You can't say, by the way, you do not have the right to an attorney. You must answer my questions, but you don't have to worry about it because anything you say will not be used against you in a court of law. You can't do that. That's a fundamental misrepresentation of the suspect's constitutional rights. And that tips the balance completely. There is no countervailing balance in this case.
I'm still going back to this view, and I don't know how it factors into the totality of the circumstances exactly, although I think that's what one needs to look at. But if Judge Fishman says, yes, the defendant could understand it that way, but Cummings's intention was agreeing not to include it in the written statement, which he did. But you're saying that's really going to a different point? That his intention, but did he find that he intended to mislead him in that way?
He found that it would be reasonable for the defendant to have been misled.
Okay. All right.
Given what he said at trial, which is that was a intentional.
Yeah, but we can't. Right.
Well, I don't know why you can't use what he said at trial to understand what the testimony was at the motion to suppress hearing. It's not really much of a change. It's just it's just in black and white there. Okay. I think the same inference is true from the record at the motion to suppress hearing.
So you say this is just like Walton, is that right?
Which one is that?
Walton's the one with the on the park bench with the friend who was the FBI agent.
Yeah, I say it's just like it's worse than that case, because in that case the agent was sincere. He thought he really could talk to him off the record. He only found out later that he could not talk to him off the record. This was an intentional trick to get somebody to talk. And it's a double whammy at trial. It's not just a single whammy, because the jury hears that you wanted it off the record, which is even worse. Makes it highlights it in a very detrimental way, and then they hear the content of it too. So it's a double whammy. This is can a police officer actually talk to somebody off the record? Can a police officer lead someone to believe that he can be spoken with off the record?
Well, there's no question that a police officer can engage in conduct which, in the totality of these circumstances, could be viewed to be so manipulative that it makes the statement involuntary, but that doesn't mean that every statement of this sort just automatically falls into that category.
No, I can think of circumstances where the rest of the balance might tip against this, but what other circumstances are there here? This defendant is told, you don't worry, nothing you say to me now will be used against you in a court of law. That's what I say he's being told. I don't know how anyone could reasonably view it in any other way. That's what you're being told.
If he had said that, I would maybe be more inclined to agree with you. But we look at what is said in context, what happens before and after, and we apply a totality of the circumstances test.
Right, but if he had said that, you would still apply a totality of the circumstances test. But what would be on the other side of the balance? What could possibly be on the other side of the balance if you said to a suspect, don't worry, nothing you say to me can be used against you? What could be on the other side of the balance?
You're saying, well, off the record obviously means I have deemed that this material will never be used in any context against you, and I just think that may be too much given the context of this discussion. Look, I don't want to say this on the record, but what a jerk. No, I'm saying, okay, that's interesting, but that's not the kind of immunity, or that's not. I mean, it just. We've got to look at the context here.
Right, but it wasn't. He didn't say to him, I don't want to say it on the record, but, that guy's really a jerk. He said to him, can I talk to you off the record? And the police officer said, yes, you can talk to me off the record.
It was a little bit, well, you know about all those sexual activities going on there. Well, what about that? Well, can I talk to you off the record? I mean, that's exactly the kind of thing, because I don't want to, overly embarrass someone or maybe say something that will get into the papers or, I mean, that's context.
Yeah, but the context is you're being lied to about your constitutional right. That's the context, isn't it?
I don't know. It doesn't strike me as necessarily being lied to about your constitutional rights.
Did your client, I should know this, but I don't, did he file he didn't testify at the, did he, at the suppression hearing?
He did not.
Did he file an affidavit?
He did.
And is that, I'm sure it's
in It's in here, but it's not on point.
Mr. Sheketoff, I want to make sure I understand what the involuntariness is here, what the nature of the involuntariness is. If we agree with you that this is a violation of Miranda and in order the statement suppressed, there's a trial, your client testifies in the defense at trial, could this statement be used to impeach him?
Not if it's involuntary.
Well, so the involuntariness here is it a Miranda?
No,
a voluntary waiver of Miranda, or is it?
There's no custody in this case, Justice Spina, so I can't make a Miranda claim. But what I say is that the Miranda decision is much more basic than that. Miranda is a prophylactic rule based on constitutional rights that you have. And as a generality, the police do not have to announce your constitutional rights to you. But in situations where there's custody, we've decided that they do have to announce your constitutional rights to you so that you're aware of your constitutional rights. But they're the same constitutional rights that you possess whether you're in custody or not in custody. And the question presented by this case, it seems to me, is can you lie to somebody who's not in custody, who you have no obligation to warn? Can you lie to them about what their constitutional rights are? Can you say to them, you can talk to me off the record? Can you say to them, you don't have the right to an attorney when you're talking to me? Can you say to them, you must answer my questions? You don't have a right to remain silent. You're not in custody. Can you say these things to a suspect? And I say you can't say these things to a suspect, that there is nothing more egregious in terms of a misrepresentation than a misrepresentation about your fundamental constitutional rights. And when that occurs, yes, it is a balancing test, but no court that's looked at this where there has been an off-the-record solicitation has found that the balance is in favor of the state.
Are there more cases besides Swinton and Walton?
No, not that I can really find. There are cases that distinguish Swinton and Walton and say something that happened here is less or more than those cases. But that's because the police generally don't do this. I mean, the police generally don't go around and give anti-Miranda warnings to people that are not in custody. I can't find another case in Massachusetts where a police officer told somebody that something was off the record and had no intention of keeping it off the record.
Thank you, counsel.
Good morning, may it please the court. My name is Melissa Johnson. I'm an assistant district.
Before you get started, so let's pick up where Mr. Sheketoff left off. Can the police say to someone, well, you can talk to me off the record and it won't be used, and imply that it will not be held against you, it won't be used against you?
Well, my response, Your Honor, is that just as Justice Cordy pointed out, everything in context. And in this situation, it's very interesting how my brother has played this out, because it was the defendant that requested that this be off the record, and the trooper acquiesced. So it's interesting because it was the defendant that manipulated the situation and tried to manipulate it to his advantage by making...
Well, couldn't the officer have said, hey, wait a minute, you can't talk off the record?
He could have, but as Justice Bostard pointed out, perhaps what was understood at that point and what Justice Fishman had found was most likely they were agreeing to not include certain remarks within the written statement. Maybe he was ultimately misled as to what was going to happen with those few statements, but at the time, because they were in the midst of writing this written statement, which, by the way, the defendant does not contest was involuntary, nor the statements before or afterwards, just these few statements that were being said in the midst of writing this voluntary written statement not be included in that written statement. And it just seems to me, here is the defendant, because we're looking at this in the context of a totality of circumstances. Here's the defendant trying to orchestrate this situation so that certain statements that might be more harmful to him are...
I mean, what's the advantage to him? I mean, when you say orchestrate, what's in it for him to make a lot of pejorative statements about gay people in general and this gay man in particular?
Well, perhaps the defendant thought by not including those more profane statements within his written statement, it would seem that there was less of a motivation on his part.
Then
Why say them at all?
So, yeah, why say them at all? I mean, I don't understand when you say manipulating the situation, exactly for what purpose?
Because it probably made him seem less, in the relationship between him and the victim, less inflammatory than it actually was. And in fact, a watered down version of those statements was included in the written statement, which the defendant does not contest. And it just reminds me of the situation that this court decided in Commonwealth versus Jordan, where this court had said the defendant miscalculated the ability to manipulate the situation to his advantage. So perhaps at the time he thought it would make him look better. In the end, it did not. But it was the defendant's idea. It was the defendant's idea to try to figure out what was going to be included in this statement, not the troopers. This was the defendant's idea. So it seems to me that now, after the fact, he's claiming that those statements are involuntary, or somehow his will was overborne. Seems to me a little disingenuous, considering the statements before were voluntary.
Don't you agree that if he were in custody and he said, do you mind if I speak off the record, and if the person said yes, it would plainly be suppressed?
Are you questioning the voluntariness or the voluntariness of the Miranda waiver?
I am saying that if he were in custody and if he gave the Miranda instructions and then later the witness said, do you mind if we speak now off the record, and if the person said yes, meaning that everything you say no longer can and will be used against you, that you have any doubt that that statement would be suppressed, yes or no?
I think there are cases that support that proposition where someone has invoked.
So the answer is
their-
yes.
Yes, they've
Okay,
invoked if it's
so,
a Miranda
but
issue.
Didn't Miranda evolve out of the Supreme Court's concern about grappling with all these different voluntariness cases and essentially used a prophylactic test when someone is in custody in order to ensure that the statements were voluntary? Isn't that the history of where Miranda came from?
It is the history, but it has evolved into a separate and distinct analysis. And here we have no issue of any coercive situation. He is not in custody. And I think that's why the question of voluntariness, as opposed to Miranda, which you need to decide custody and interrogation, why voluntariness continues to be that totality of the circumstances
Well, it certainly is totality, but the court shows that everything you say can and will be used against you was so important that it had to be included in Miranda. And now you're asking us to say that an officer can say, you can speak with me off the record, and it can still come in. Isn't that contrary to the very spirit of what led the Supreme Court in Miranda to establish that among the very statements that must be made to ensure the voluntariness of a statement that's made in custody?
With all due respect, Your Honor, I disagree. I think they are separate and distinct analysis. I think voluntariness necessarily requires that question of whether someone's will was overborne and looking at all the circumstances in determining whether that statement is the product of a rational intellect. Whereas Miranda has recognized that in certain situations where there is coercion, not this situation where there is coercion, there needs to be that prophylactic advisement of the rights.
So if you prevail here, do you advise officers to tell individuals that we can speak off the record?
No, Your Honor, I don't advise
Why not,
that.
if the court has blessed it?
I would advise officers to ensure that within the totality of the circumstances of their interrogation of the suspect, that there are not circumstances that indicate that the will is overborne. And in this situation, the trooper...
Try my question. If you are speaking with police officers, if you prevail, is it not the case that you can say there are some times in which it's appropriate to say what you say is going to be off the record? Because the SJC has said that does not affect the voluntariness of that statement. So there are circumstances where it's okay.
Your Honor, I would hope that this court would not just simply come out and say that officers can say that. I would hope that the court would come down with some kind of statement looking at this case in the totality of circumstances, looking at the fact that this defendant, 50-year-old man, intelligent, educated, owner of 2 businesses, chooses the time and place of this interview. He's not in custody. He's allowed to leave that room anytime he wants to talk on the phone. He is told by the trooper that he can leave at any time that he wants to pick up his son from his ball game. And we can reschedule at any time that you would like.
Okay,
The interview lasts
so you're
less
saying
than
that
an
as long
hour.
as it's plainly not Miranda, as long as there's no custodial feature, it may be okay to say that?
If in a situation that is so uncoercive such as this one, then in these circumstances, it was fine, Your Honor.
Would you feel any different if the statements made weren't arguably a worse version of, the unwatered down version? I mean, they weren't really connected, but they were. Let me tell you, yeah, I did. I set that boat on fire. I was delighted to do it. I can't stand the guy. If that was the statement, would you have exactly the same reaction? Not. It's not the content.
It's not the content, it's the circumstances, and this court has been clear about it. And it's important not to focus just on one circumstance here. There is a multitude of circumstances that point to the fact that this statement was voluntary, and indeed all the cases before this court that have talked about actions on the part of the police officers that have resulted in suppression or resulted not in suppression. Focusing on that one factor has never been a course that this court has taken in the past.
And it's like any other case of ours?
I haven't been able to find something quite on point. I think Commonwealth versus Jordan, which I just had quoted from, is somewhat like this case.
Well,
But
we certainly have overlooked or condoned lies that police officers have told to defendants to kind of, or people to kind of coax information out of them. But they were always sort of lies of a factual nature. This is not that kind of a lie. And where, apart from this being a non-custodial interrogation, where the defendant was told in advance that anything he said could be used against him in a court of law, and then where the defendant says, I'd like to go off the record, and the police officer says, okay, that's really sort of an operational promise. It's not a lie. It's not a factual lie.
Well, it's interesting you point that out, Your Honor, because there have been cases where a person who is in custody, who has perhaps invoked their right to remain silent or right to counsel, and then the trooper or the officer tries to get them to waive it by saying such things. That's a whole different situation. And those cases, and I believe Jackson and Taylor are the cases that talk about that, is an entirely different situation from the situation here where he wasn't advised any differently. He wasn't in custody. He wasn't given his Miranda warnings. So there was no invocation, there was no advisement of rights, and then saying, oh, but don't worry about those rights. We'll just do it off the record. There was nothing like that. This whole interview was, in many senses, orchestrated by the defendant. He chose the time and place. He's allowed to leave whenever he wants. He's the one who brought up the fact, can we do this off the record as we're doing the written statement, which could be interpreted by the trooper as, okay, I won't include it in your written statement. But this guy is savvy enough, as the motion judge pointed out. He's savvy enough. He's had experience with the police before. He has a business where he works with the troopers, and he's brought that up to to the investigators here. He's savvy enough to understand that something may not make him look good, and so maybe I won't put that in my written statement.
Oh, so he's savvy enough to say something that ultimately is stupid, knowing that it might be used against him at trial? That shows his savvy?
But he's in control, or he thinks he's in control of what he...
Because he asked the officer whether it was off the record, and the officer said yes.
But the question is, was his will overborne?
You know, I don't know whether it was Jordan, and I'm having a bit of a senior moment here, but going back to what Justice Spina was talking about, misrepresentations with respect to facts, which we say is a factor, but not determinative. But didn't we decide a case where the misrepresentations with respect to facts became misrepresentations with respect to the right to tell your story to a jury? And we said at that point, when you tell someone, if you don't tell me now, you'll never be able to tell a jury, that was a misrepresentation of a constitutional right, which was different.
Your Honor, I think you might be either talking about Dustin or Meehan, and I could...
I'm talking about neither of those two cases.
Okay. DGM Batista?
No. All right. I even wrote this opinion, so that shows you exactly how old I am.
There is usually a combination of factors in the cases that I've reviewed where perhaps the Commonwealth has overstated the evidence, and then that's a separate situation, and then perhaps in combination with some kind of promises of leniency or something like that. There's always a combination of something. And the fact that the defendant may be somehow vulnerable, whether they're intoxicated or young or uneducated, or whether there's always a combination between some of these factual expressions that the trooper may make, along with some of the legal expressions as far as promises or, you're not under oath, so you can tell me whatever you want, in combination with the actual defendant himself. And there's always, and that's why this court has continuously used that totality of circumstances, because every situation is going to be different. But in this situation, where absolutely every factor is weighing in favor of voluntariness, in the context of his entire oral statements, the written statement, his background, his demeanor, his control of the situation in terms of the time and the place and his ability to leave, the fact he wasn't arrested at the end of this. Even the statements that after the trooper became a little confrontational and saying, I don't believe you, those my brother doesn't challenge. So it just...
What if the police officer had been more specific and said, look, I understand you're reluctant to tell me what happened here, but if you tell me, this will not be used against you? What if it very specifically said, not just off the record, if you tell me, this will not be used against you? Different case?
Mm-hmm. I think you still use the totality of the circumstances argument, but that may be a stronger case for the defendant. However, again, you're looking at all of the circumstances. Could this guy have really believed, in all of his experience, of his age and his demeanor, could he have really believed? He's talking to a trooper who explicitly says to him, I want to talk to you about the boat fire. I need you to be explicit to me. Tell me what happened. Is he really going to think, well, now this guy's telling me none of this is going to be used against me? Is that really something that we should believe that he's taking to heart? Again, it is a stronger case for the defendant. That I will admit. That thankfully is not the case here. But again, it's a totality of circumstances analysis that this court will undertake. And in this case, again, we've got this situation where we have one factor that my brother is challenging. All of the other factors are pointing to voluntariness. We have one factor where my brother is saying that there was some kind of misapprehension. But given the totality of circumstances and given this defendant's control over the situation and the non-coercive situations, all of these circumstances point to the fact that these few phrases were in fact voluntary. If there are no further questions.
And am I correct that we'd be the first court to say that if you were to prevail?
I think in Massachusetts, as far as I know, in this particular factual scenario.
How about anywhere? How about anywhere in the United States? Are you aware of any case in the United States which has said that when a police officer says it's off the record, it may be admitted?
I'm not aware of any other one.
All right, thank you, counsel.
Thank you.
All right.